Now I'd like to introduce First Assistant DA Robert Listenby, who, along with his team, was the driving force behind our new policies and the related reforms.
Thank you, DA Krasner. I also like to thank Lily and Bree for their statements today. Sometimes we forget, what's really happening to our children when they go into placement, and we have the good fortune today of having two young ladies come here and explain their personal experiences and how deeply those experiences impacted them in negative ways. District Attorney Larry Krasner was elected with a powerful vision and mandate to reform the policies of the Philadelphia District Attorney's Office as they apply to the juvenile justice system. From the very beginning, he insisted that his staff develop policies that treat kids like kids and not like small adults, and that focus on rehabilitation and second chances as opposed to punishment. He also insisted that we pay close attention to the needs and concerns of victims and witnesses that testify in juvenile proceedings, as well as the constitutional rights of children who are defendants in those same proceedings. In addition, he's required his staff to take into consideration the interests and concerns of communities where our children reside and listen to the concerns of community members. With these ideas in mind, I would like to talk about the 7 policies that we are sharing today. There are 3 very important principles that apply to each of the 7 policies. I will discuss them in detail as they apply to the first policy, but I won't discuss them as they apply to the other 6 policies, though it should be understood that they apply to each of those policies. You have copies of them so you can read how they apply. First, the policies are written as guidelines, or in legal terms as presumptions. They are to be applied in an individualized way to the facts, the law, and the circumstances of each case. They are not rigid dictates from District Attorney Krasner or his supervisors. Second, under District Attorney Krasner, each assistant district attorney is given the discretion within limits to decide how to handle his or her cases. And third, each of these policies comes with exceptions that limit their application to very serious cases. Let me go first to the first policy on juvenile pre-adjudicatory offers. This policy is designed to increase diversions, the number of children who stay out of the juvenile justice system. Here, we offer deferred adjudications in most cases. Children are placed under court supervision for a period of time without an adjudication of delinquency, which is the juvenile equivalent of an adult conviction. If a child complies with the terms of the deferred, the case will be dismissed and the record can be expunged. So we're trying to divert more cases with policy number 1. I want to go over the exceptions because these apply to many of the other policies, but in different ways. There are several exceptions which I want to focus on. First, a deferred may not be appropriate if a child has a prior adjudication of delinquency, is charged with a possession of a gun, is charged with aggravated assault and has intentionally inflicted significant or serious bodily injury on the victim, where the youth is charged with rape, sexual assault, involuntary deviant sexual intercourse, or aggravated indecent assault, where the youth is charged with a felony of the first degree where a weapon is used, or where the youth is charged with invasion of a home of another with a weapon. So the policy don't apply to those specific exceptions. Where a deferred is inappropriate, a reporting consent decree, which is a 6-month supervision, can be made available with the expectation that an expungement can occur 6 months after a child is discharged from court supervision. Under the current rules, children have to wait for 5 years after discharge from court supervision before records can be expunged. So we're trying to, kids who come into the system, we'd like them to get out and not have them permanently stigmatized or stigmatized from 5 years, barred from getting certain kinds of jobs or achieving certain kinds of educational goals. Policy number 2 focuses on juvenile reporting consent decrees and extends the offer of a consent decree to all cases where there is a misdemeanor as the lead charge. Once again, children charged with misdemeanors, we want to get them out of the system, so we want to give them consent decrees. According to research on juvenile probation, there should be no more than 3 conditions imposed on a child who's on probation. What we find under current practices is that many of our children are given 3, 4, 5, 6 conditions. What is that? That's the prescription for failure. How can a child complete all the different conditions placed on them and at the same time go to school successfully, and many of them are working? So we want to restrict the number of conditions to 3 for almost all the times that our children are placed on probation. Finally, Children placed on reporting consent decrees should not be required to complete more than 25 hours of community service. Again, if you have 100 hours of community service or 200 hours of community service, you don't have time to go to school, you don't have time to go to work, you don't have the time to take care of all the other kinds of obligations you have. Policy number 3, it is our goal to reduce the number of children held in detention. Why? Because we know that once a child is held in detention, the likelihood of going deeper into a system is pretty well established. So we are recommending that all of our assistant district attorneys, or we're requiring them to recommend alternatives to detention where children are arrested, where they have bench warrant hearings or violation of probation hearings. Once again, this policy is crafted with several specific exceptions designed to communicate with victims and protect the public. Policy number 4, under juvenile disposition is our juvenile disposition policy, where a child is found guilty of an offense and placed on probation. An assistant district attorney should ask for the least restrictive community supervision program available, and again, with no more than 3 conditions of probation. If the court commits a child to a residential placement, an assistant district attorney should recommend the closest placement facility that meets the needs of a child. We want them closer to home. We want them to be able to meet with their families. We want them to be able to have families engage with them while they're in placement. Also, we are no longer recommending specific lengths of time when kids are going to placement. Assistant district attorneys should also not recommend that a child found guilty of committing a misdemeanor offense be sent to placement, except with permission of a supervisor. Also, an assistant district attorney may not recommend that a child under the age of 14 be sent to placement without the permission of a supervisor. Why? Because most children who are very young should receive appropriate community-based treatment, not be sent 200-300 miles away from home and thereby causing greater problems for them to adjust when they return back to their families. Also, no child should be sent to placement that cannot meet his or her educational needs. Many of our children who are going into placements have individual education plans. They go to places where those individual education plans cannot be met. They come back, they have to start all over. Many of our kids go to placement, they come back, they don't get credit for the time they were in school and in the other placements. So they really have to start all over, as we heard from one of our young people who was speaking here earlier. Our policy on juvenile review hearings. Residential placements should only be sought if 6 listed community interventions have proved ineffective or impossible. So we're giving our assistant district attorney 6 alternatives before you get to the point of looking at placements. Residential placements should not be sought for youth who've been found guilty of 2 or fewer misdemeanors. So you've got to get a couple of misdemeanors before we think you should even be considered for placement. We do not want our kids to go into placement unless it's absolutely necessary. Probation violations such as missing curfew, failing to attend school, and the use of marijuana should be treated with community programming. Children should never be placed in a residential facility for failing to pay restitution or court fees. Our kids are basically being sent to debtor prison to pay for court fees and restitution when adults can't be sent there, and we don't think that's appropriate for our children. Policy number 6, the use of solitary confinement. The district attorney's office strongly opposes the use of solitary confinement. Keeping children in isolation can have long-lasting and devastating consequences on youth, including trauma, psychosis, depression, anxiety, and an increased likelihood of self-harm. There's absolutely no research suggesting that solitary confinement is an effective means of controlling the behavior of young people in custody, and yet isolation is not uncommon, particularly for those youth held in adult facilities. The district attorney's office urges the Philadelphia Department of Prisons to rethink its policy on juvenile solitary confinement and to train its staff in alternative methods of discipline. We ask that our juvenile justice partners monitor the placements when we send children, Philadelphia children, to ensure that these methods are never used on our children. And final policy is the juvenile bench warrant policy. Assistant district attorneys should oppose the imposition of these kind of bench warrant sort of provisions. Bench warrant hold, bench warrant do not release, judge only bench warrant, or bench warrant hold, do not release, commit to placement upon apprehension. Why? Because these kinds of bench warrants violate the constitutional imperatives that children have. If you have a bench warrant and you're brought back in, the reason you didn't appear was because your parents didn't give you the money to get on the bus to come, or your parents held you out and didn't bring you down to court. Why should you be sent away for placement when something like that happens? That kind of thing is happening to our kids. We also know that when kids come in on bench warrants, what happens is, if it's a bench warrant hold, do not release, kids are held in our detention center for 7 to 10 days, usually 10 days, until they can appear before a judge. The average cost for holding a child in the detention center is somewhere between $600 and $700 a day. Why should we hold a child in our detention center for that length of time when if you brought them before a judge immediately the same day or the next day, the issues could be resolved and they could go forward and with whatever appropriate judgment the judge decides. Finally, if you look at bench warrant hold, do not release, commit to placement upon apprehension, that is totally absurd. You have a child who didn't get into to court because the parents didn't provide funding. The child is held and committed to placement that will cost $150,000 to $200,000 a year per child. And for what? Because they didn't get to court and it was beyond their control to get there? Those kinds of policies should be eliminated in family court. In conclusion, I'd like to make a few comments that really recognize something that people really need to understand. There have been significant achievements by the stakeholders here in our juvenile justice system. As DA Krasner pointed out, the number of petitions has declined from 10,000 to 2,400 between 2001 and 2018. Also, the number of placements has declined from 976 to 516, or 47% between 2013 and 2018. In spite of this progress, if you ask the citizens of Philadelphia if they would be confident if their children or grandchildren entered the juvenile justice system, that your children would come out better at the end than they were at the beginning, I think you'd get a resounding no. I've asked judges and defense attorneys, prosecutors, all across this nation, if they felt that they had confidence in our juvenile justice system, and very few do. So if that's the case, why are we sending everybody else's children but not our own into these systems? We have to correct them and make them safe for our people. As far as education is concerned, if only 36% of our kids are actually graduating from high school after we send them to these very expensive placements, perhaps we need to rethink the system altogether. As Philadelphians, we've watched with great admiration as New York City has adopted and refined the close-to-home model and returned over 500 children from out-of-home placement facilities across the vast state of New York to New York City. Several of our leaders have already visited these programs. Many of us are also aware of the important work done in Pittsburgh, where the family court has adopted an entire trauma-informed court model to address the needs of its children. In 2017, Judge Kim Berkeley Clark, administrative judge of Allegheny's Family Court, who developed the trauma-informed family court model, was recognized as one of the top judges in the entire nation by Chief Justice Roberts of the United States Supreme Court. As Philadelphians, we will seek to find our path to greatness, borrowing from other models and adopting them to our own unique needs. But our children can no longer wait for the perfect solution as they pass from adolescence into young adulthood. District Attorney Krasner's vision and mandate have given those of us in the District Attorney's Office the opportunity to exercise our discretion to improve the lives of our children by making recommendations to the stakeholders in this system. We are hopeful that many of them will join us in support of these recommendations. Thank you.